Something here, that's all set. Yes. All right, so this is the last chapter we're covering on contracts, so the third chapter. Of course, we really covered a minimum amount about what you would learn about contracts if you went to law school, but hopefully we covered enough, and with the assignment we have due this week, that you are now more aware what it means to have a contract and what certain sections of the contract actually mean, and why it's important to have contracts in certain instances, and what needs to be in writing, what doesn't, what your rights are, and so forth, right? So, both in your personal life and in a business situation that you might eventually find yourself in when you work for a company or even have your own company, right? That's the whole purpose of having a business law class for business students, right? All right, so this talks about assignment and delegation. So assignment is sometimes you can assign the rights under a contract to somebody else, right? There's an exhibit on page 10.1, on page 266, but I'm not going to go there. You'll see it when you look at the textbook, when you read the textbook, which you actually should have done by now, right? So give me an answer give me an example of when rights were assigned to somebody else. Yes.
When people bundled like mortgage debt and sold it to other people.
Yes, very good example. Any debt, any mortgage or a credit card or auto loan or any loan, right? That happens mostly with mortgages. So I am a bank and I give Diego a loan to buy himself a $5 million house. I give him $4 million. He comes up with $1 million, right? We close, it puts a down payment and everything, and he starts making payments. I'm the bank and I decide, I'm actually gonna sell this loan to another bank and get money from the bank. I'm gonna get less than the interest I would have made if I kept the loan, but I'm gonna have the money now. And now I can use that money to give another person a loan. And the bank buys the loan and makes some profits. Both banks make profits in this transaction, right? Now the new bank has the right to receive payments from Diego, right? That's assigning rights. As the bank, do I have to get Diego's permission to sell my loan to another bank? No, I don't. No, it's very common practice. The thing that has to be, you have to be careful though, the new bank has to honor the exact same terms of the contract that I had with Diego, right? They can't say, oh, we're going to change interest rate. They can't say, we're going to give a higher late penalty fee, and so forth. It has to be the exact same terms. And I have to notify Diego that now the new person he has to send the checks to is the new bank. There has to be notice. I have to give notice, right? Any questions about that? Yes, Diego.
When you have like concepts of like renegotiating contracts, especially for loans, of like, hey, in 5 years we can talk about renegotiating your interest rate. Is that something that also has to be honored?
Usually loans don't say that. They don't say we'll renegotiate in 5 years, but what you do have is flexible rates, or they're called, like if it's 5 years, 5-year arms. So 5 years, it's a certain rate, and after 5 years, it's flexible, but that depends on the market rate, on the prime rate and what the Fed says and things like that, right? So that's all set for the life of the loan. You don't renegotiate, right? Yeah. If you had some kind of contract that did have some renegotiation terms, sure, they'll renegotiate, but they don't have to lower the rate. They can just say, yeah, we negotiated, but we're not coming to an agreement, so we're keeping the original terms. Right? Yeah. Any other questions? Oh, I do have that picture. I'm sorry. I pull up the wrong slides. Let me just check real quick. Hold on 1 second. Just want to make sure I have the shorter version so we don't take too much time, since I want to talk about the assignment at the end of class. Let's see, chapter 10. No, that is the right one. Okay. I had thought I took it out. Anyway, so here, there's an original contract. My example was Diego and myself, and then I assigned it to Carmen, the new bank. Now Alex has an obligation to pay Carmen instead of pay me, right? So, rights cannot be assigned in certain instances. When a statute expressly prohibits assignment, for example, workers' compensation benefits. If I'm on workers' compensation and I receive benefits, I can't assign those benefits to anybody else. I mean, after I receive the money, I can do anything I want, but with my money, but I can't assign it to anybody else to receive that, right? When a contract is personal in nature, give me an example of that. Yes,
Like if you were told to babysit someone's kid, you can't just delegate that assignment to some other random person. Like,
no, that's delegation. You're talking about delegation. I'm talking about assignment, but you can use that in a case of assignment too. Assignment is the rights, you receive rights under the contract. So the babysitter is the one who does the work.
then you would, you can't just assign the duty or the job to.
No, don't use the word assign. You can't assign the rights. You don't assign duties. You delegate duties. That's the next topic. But I'm going to use that specific example from the other side. So let's say I'm hiring a babysitter, right? I'm hiring, what's your name again?
Evan.
I'm hiring Evan to babysit my daughter, who's very sweet and, easy to babysit and things like that. And I have a contract with him to do that for 1 year, every day, 5 days a week, 8 hours a day, right? We have a contract. And I decide my daughter is so good, I don't need a babysitter. So now I'm assigning him to babysit my sister's son or my sister's daughter instead, who is a horrible child, difficult to deal with. It's just exhausting. I can't do that because it's personal in nature, because he did not agree to babysit that child. So I can't assign the rights to receive babysitting services to my sister's child because it's personal in nature. Yes, Diego.
Say like I drew up like a personal loan to give, I don't know, my uncle or something, like a couple thousands of dollars. Is that still personal in nature for me to like turn around to the bank and like, hey, I have this contract with this loan, do you want to buy it from me?
No, it's not really personal in nature. Just because you're related doesn't necessarily make it personal in nature. It doesn't make a difference to your uncle whether he writes the checks to you or to the bank, right? But it makes a difference to the babysitter, to Evan in this case, if he babysits my child or my sister's child. Right, does that?
Yeah.
Clear it up? Okay, yeah. So, and I'll use that same example when we get to delegation, since Evan brought it up, right? So, when an assignment will significantly change the risk or duties of the obligor, so when the contract prohibits assignment, you cannot prevent the rights to receive funds, right, under a loan, so, for example. Ownership rights in real estate, you can't assign it. Negotiable instruments, well, actually, you can't sign over the check to somebody else, right? But there are significant rules. Rights to receive damages for breach. So if I receive in a lawsuit or in a settlement, I receive rights to receive damages because somebody breached a contract I entered into. I can't assign those rights to somebody else to receive the money. I have to be the one that receives it. Yes.
Could you give an example for ownership rights in real estate? Is it like the same thing? Like if you negotiate a contract with someone, like, hey, I'll buy this property, you can't have someone else get ownership of it?
Yeah, it's a very
That's a straw buyer or a straw seller.
yeah, can you explain that?
Yeah, so I think, are you asking like if I were to buy a property, I can't then give it to you?
Mhm.
Yeah, I think that's a straw buyer that's a straw buyer, it's one person using somebody else's identity to kind of.
Kind of,
acquire
yeah,
property,
yeah.
And that's not legal.
Because I may not want to sell my house to that person, right?
Mhm.
So I may want to sell, I may want to pick the one that, has values that I have that fits into the neighborhood or something like that, right? Yeah.
But once you have, but once you have ownership of it, can't you change like? Can't you transfer that asset to someone else?
You can't just transfer assets, you have to do a sale, yeah, because there's a lot of value involved and that would, transferring assets means they're receiving a gift of a house or something like that, which has tax implications. The only time you can transfer a deed, that shows the owner is between couples, between married couples, right?
Okay.
Otherwise, like you could just, if you get old, you could, if I get older and I want my children to inherit my house, I could just transfer the deed into their name so they don't have to pay inheritance tax.
Okay.
But I can't do that. You can't do that.
You can't transfer to your children.
No, you can't.
So that's why people put it in a trust.
Exactly.
And then they put the beneficiary as a trust as their children.
So exactly, that's why, so it's complicated, it's a different part of the law, but,
But you can do it between married couples.
yes, between married couples you can, or let's say you were single, you bought the house and you get married, and you wanna do it in both names, or maybe you're separating and one spouse lets the other spouse have it, there will be no tax implications for that, right? But in the case, what you mentioned, I'll just buy the house and sneak in, just transfer the deed, no, but you could sell it later, at a later date, right? Yeah. Does that answer your question?
Yeah.
Okay.
Thank you.
There has to be notices of assignment, so that somebody else now has the rights to receive whatever is under the contract, such as in the loan example, the payments. The next topic is delegation. So delegation is transfer to someone else all or part of the duties under a contract. Let's see, I guess I don't have a picture for that. So this is when, when you have contract with a contractor to do work on your house, build an addition to your house. You sign $100,000 contract to build you an extra room, right? So that contractor is now going to use subcontractors. A subcontractor who's gonna do the foundation, a subcontractor who's going to do the walls, another one who might do the roofing and so forth, right? You don't do a contract separately with each subcontractor. The subcontractor works for the main contractor. The contractor is assigning part of the duties to somebody else, right? So let's talk about duties that cannot be delegated when duties are personal in nature. And Evan, this is what you were trying to say. Do you want to say that example now with babysitting?
Oh, no, I was just saying that, if I'm babysitting a kid, you can't just, tell me, you can't just kind of change it up and be like, hey, you're gonna go babysit this person, or you're gonna kind of just change the personal, aspect of it, yeah.
So yeah, if Evan has a babysitting job, I hired Evan to babysit my kids because he's a great babysitter. He can't just send somebody else to babysit my kids. I wanted Evan, I'm paying for Evan's services, right? Yeah, so, other examples when it's in personal in nature. Or actually, let's go to the next one. I think that pretty clearly explains it, right? Or Diego, did you have one?
Not an example for personal in nature, but I've heard of the kind of sticky gray area where people get hired for a certain job and then delegate that work to outsourcing and then turn in that work. Is there a certain percentage of your involvement that needs to be in there that makes it okay, or?
Well, if you're an employee of a company, you cannot delegate your duties to somebody else.
Okay.
Yeah, but you can, if you're a subcontractor, if you're a contractor, you can subcontract under certain circumstances, but not when the performance by a third party will vary materially from that expected by the obligee. So if you're hiring somebody for their expert knowledge and they have a maybe really great reputation and they're very expensive because of that. Let's say you hire a plastic surgeon to perform this very expensive plastic surgery, right? and you're willing to pay triple the amount what it would usually cost because she's such an expert, right? That surgeon can say, okay, I am gonna delegate to one of my junior surgeons to do the surgery. Right, because now the value would vary and the expertise, especially the expertise, right? Yeah. And then sometimes the contract expressly prohibits delegation. Oh, and that was the same with assignment. The contract can say there's no assignment allowed. And the contract can also say no assignment, no delegation. Quickly back to assignment, very often, rental contracts, apartment leases and so forth have a clause in there that prohibits assignment, meaning you cannot sublease, you cannot give the rights to live in that apartment to somebody else. Or they have a clause, if you assign, the landlord has to agree and all that stuff, right? Yeah. Very, very common. If you do that in your paper this week, pay attention to that clause, right? Because that's one of the questions. Anyway, same with delegation. If it says it cannot be delegated, it simply cannot be delegated. The receiving party must accept the delegation of duties. You can also have assignment of all rights. I did have one time, I hired a hardwood guy to resurface my hardwood in my house, and he turned around and had the complete job done by somebody else, right? By a subcontractor. I'm going to stay here before I go to third-party beneficiaries. One of the important things is when you when you delegate duties to a subcontractor and something goes wrong, the subcontractor does something wrong, who is responsible? Usually the original person is responsible. You will go to because you don't have a contract with a subcontractor. You have a contract with a contractor, the main contractor. You're going to go to the main contractor. And this actually happened with my hardwood. There was something that was not done properly. And I went to the main contractor. And then the subcontractor fixed it. It was still not satisfactory. I went back to the main contractor, and then the main contractor fixed it. You can delegate duties all you want. You are still obligated for performance. It does not release you from performing. Just like it's same with assignment. When you assign the right to somebody else to live in your apartment, in other words, when you are a tenant and you sublease your apartment, you are still legally responsible to fulfill the duties that you have. In other words, pay the rent. If your subtenant does not pay the rent, you can't say, well, I subleased it. They didn't pay, so I'm not paying. You are still obligated to pay. Keep that in mind when you assign rights or delegate duties, right? Any questions about assignment and delegation? All right, next topic is third-party beneficiaries. There are intended beneficiaries, creditor beneficiaries. Oh, I don't remember that condo unit water leak. Does anybody remember that case?
Oh, yeah.
Yes, go ahead, Evan.
I believe that's the case where, like someone's water was someone was misusing their kind of sink or something like that and was messing with the plumbing, and a person below the condo they were living in began to see flooding in the roof, and there was water dripping down. But since the person that was misusing the equipment was I don't have a contract with you, I have a contract with the landlord, and I didn't break any of those terms, but it was claimed that one of the one of the beneficiaries or unintended beneficiaries was the person living underneath.
Okay.
I think it's that one.
Okay, that's right, that does ring a bell. So just because you don't have a contract with that person who caused you to have damages, in this case, imagine you have a tenant above, or you have a condo owners, I think they were condo owners. You have a condo above that causes water damage to the person that lives below you. So the one above has no contract with the person that lives below, but has a contract with a, I don't know, HOA or something like that. Was it owners or was it tenants? Do you remember?
I think it was tenants.
Tenants, okay, rent tenants even more so, because the HOA is a different type of contract. So I would say, well, I have a contract with my landlord, but not with my tenant. But the tenant is in this case an intended beneficiary, right? They are just because they live there, they are protected as well. Yes, Diego?
Will there also be like some aspects of like split liability? Because if they said that they weren't misusing, or if they said that they were doing things within the rights of their contract, then there could be implications that like, hey, maybe the pipes weren't that great.
Yeah, there would probably be some investigation saying maybe it was something that the landlord contributed to. And we talked about contributory negligence before, right? When we talked about negligence, then they could say, well, the landlord is part fault, 30% fault, and the tenant is 70% fault, or something like that, yeah. You could, but then you have to, go and investigate and inspect and all that stuff, right? Yeah.
Have to sue everyone.
Yeah, yeah, exactly. Donee beneficiaries contract may express purpose of to give a gift. The most common one is actually life insurance, right? Who gets, if you have life insurance, who gets the money if you die? You have to specify that when you have life insurance, or when you work somewhere, when you have a job. A lot of companies provide you life insurance, which usually is very often in terms of if you die, they pay you to your beneficiary your annual salary, 1 year annual, 1 year salary, right? And you have to let your company know who your beneficiary is. In California, by law, it is your spouse. If you don't want to name your spouse as your beneficiary, they have to sign some kind of agreement that they're okay with it, right? That's anyway, the most common third-party beneficiaries would be recipients of life insurance premiums. I mean, not premiums, but what are they called? Benefits. Questions? Oh, more about it, actually. Incidental beneficiaries is a third party who benefits from a contract, even though the contract was not formed for that purpose. An incidental beneficiary has no rights in the contract and cannot sue to have it enforced. So here is an example of Castillo versus Tyson. So there was a boxing match. And which one was the one that bit the ear off? Was it Tyson or Castillo? Tyson bit Castillo's ear off. I mean, I'm sorry, Castillo was not one of the, never mind. Never mind. Castillo is the customer watching the match, right? And he watched the match that was over in like a few seconds, a minute or something like that. And then Castillo sued Tyson because Tyson violated his contract and did something that ended the match, right? Violated, but Tyson had no contract with Castillo. Castillo had a contract with the event organizer and he got what he paid for, a boxing match. It doesn't say it's going to last a certain amount of time, right? So he had no privity of contract. That means he had no contractual relationship with Tyson. That's what privity of contract means. We did cover privity of contract when we talked about product liability. When you buy a product, it's different. When you buy a product and a friend uses the product who has no privity of contract with the manufacturer, right? Because your friend didn't buy the product, but gets injured while using the product, in that case, yes, they can sue the company, even though there was no privity of contract. But that's because of negligence or product liability, yes.
Could Castillo have sued the network company that was putting on that?
The event organizers?
Yeah, because for misrepresentation of their product or their service.
Probably not, because there's nothing that guarantees you a certain length of the game. It doesn't, the tickets do not say the game is going to last at least 45 minutes or anything like that. The match is over.
But if they like misrepresented it, it's like weeks on, because like weeks before certain like matches or certain games and things like that, there's a lot of talk and there's a lot of promotion that like emphasizes like how great of a game it's going to be, how great of a match it's going to be. Like this is like the, very often used terms of like, this is the match of the century, or this is like
Oh, yeah,
a
good.
colossal thing. So I'm just wondering if that like certain amount of hyping up can cause a misrepresentation if the match ends up being like a total disaster.
We will actually talk about that in the next chapter we cover, which is chapter 13, which is consumer laws, right?
Mm.
And no, that he couldn't have been successfully sued them because that's puffery. That's called puffery. It's like, this is the match of the century. It's opinion. It's an opinion. It's not a fact. This is the greatest match you'll ever watch. Says who? Says me, right? So, yeah, no, that's, and we will cover that in chapter 13. But that's a good question, yeah. Okay, when can contracts be discharged? Next topic, right? Discharged by performance, when performance is completed. Finito, we're done, contract is done. Buy a car, the car has been delivered, I paid in full, we're good. We say goodbye, right? That means, by the way, that is when a contract is executed. Until everything is done, it's still executory, right? Another question in the contract assignment. Substantial performance, what is substantial performance? When most of the contract has been performed. It can be discharged, or the party that hasn't completely performed can still be held liable to perform the remainder, right? Performance to the satisfactory of another. When is so if I hire somebody to paint my portrait, and there are some samples and things like that, and you know, I want them to make me even look prettier. No, I want rosier cheeks. No, I want bigger lips or whatever, right? Until I'm satisfied, that contract is not completed, but it has to be reasonable, of course. I can't let it drag on for years and hire this painter who has to make some edits every week for up to a year or something. That would be unreasonable. Yes, Diego.
Would eventually a jury of your peers have to determine whether that's reasonable or not? Or is
Yeah,
it the
the
judge?
court, or is it what?
Would it be like mostly a judge or a jury?
Well, it depends if the defendant wants a judge or jury trial.
Oh, okay, they get to decide.
Material breach of contract. What is a material breach? When something gets breached that changes the value of the contract, right? Where what was promised wasn't that material wasn't delivered, or that quality of material wasn't delivered, right? Where now let's say I'm asking somebody to make me jewelry, and I want 18 karat gold. And they use 14 karat gold. I can now discharge this contract, right? Because there was a material breach. I don't want this anymore. And here's a word that was very difficult for me to pronounce. I just have to say it slowly. Anticipatory repudiation of a contract. I probably still pronounced it weirdly. Anyway, that word is one party refuses to perform duty to do unfavorable outcome because of price changes. Breaching party must notify the other party. So let's say I'm a salmon farmer or fisher. I do, wildly caught king salmon. And I have a contract with a restaurant restaurant wholesale distribution or something that sells restaurant supplies. And the contract says I am going to supply X amount of salmon weekly at this price. Something happens, there is another bad oil company has a huge oil spill. And the amount of salmon is now limited to a certain area where there's no oil. So very small. And it has become extremely difficult and expensive to get that salmon now. So it's now the pricing. Oh, I'm not a fisher, I'm actually a reseller. So now I'm paying so much more for the salmon that if I sell it at that price to this company, I'm going to make losses, right? In that case, I have to just notify them and say, I can't do this anymore because it's too expensive. I can't sell you at this price anymore. Questions? Yeah.
To get around that, is it okay to like put in the contract of like a certain percentage below the market rate? So like you agree like, oh, I will give you, because you're buying in bulk and because you're such a consistent customer, I will sell this fish to you like 20% below the market rate.
You can do that, but what if the market rate goes so low that you're going to lose money? Yeah, so, yeah.
does this also like, is this where the impossibility to execute?
Yes, it's very
Comes
similar, impossibility to perform.
Or is that something different?
It's kind of, it's pretty
Okay.
much similar, it's just, performance is also like physical performance besides. This is just based on, prices,
Got
but it's kind of the same thing, right, exactly. Discharge by mutual rescission, two parties decide where we do, there are some things going on in the contract we both don't like, we're gonna revise it and the old one will be discharged. Discharge by novation is third-party substitutes in, there are third-party substitutes in a contract. There has to be a valid previous obligation, of course, an agreement by all of the parties to a new contract when a third party enters now, right? The extinguishing of the old obligation, all the old obligations, the old contract is no more valid, basically. And there will be a new valid contract. Novation means substitution by agreement of new contract for old one with old rights terminated. So the old contract becomes completely void and invalid, and a new contract is formed. And then there's discharge by a court of satisfaction. You're satisfied we're discharging the contract. The buyer usually has satisfaction, right? Discharge by operation of law, if there's a material alteration of the contract, it's again, material means the value changes. Statutes of limitations, usually 2 to 3 years. If you form a contract and nothing has happened, no work has started, nobody bugged anybody, after 2 or 3 years, you can't really enforce it anymore, right? You can't go back and say, I remember, plus prices have changed by then and stuff like. Bankruptcy, you don't have to fulfill your contractual obligations if you file for bankruptcy, some of them, right? Although I would not recommend anybody to do that. It stays with you for the rest of your life, right? Impossibility to perform is when performance is impossible or temporarily impossible. Let's say I'm a dancer and I have a contract to perform at these events and I break my leg. I can't perform, right? Or maybe temporary impossibility. Maybe it's a weekly event and then maybe after 2 months I can go back. But I will not be punished because I can't perform now. Right? That contract will be discharged. Commercial impracticability is similar to the example I just gave, where prices change, availability of products or supply change, a doctrine that may excuse duty to perform, right? And frustration of purpose means a court-ordered doctrine under which a party will be relieved of duties to perform, and that's usually happens when there's impossibility of performance. Yes.
For statutes of limitations, what is the like minimum that, so say I pay for a service, right? What is the minimum participation on my behalf that I need to prove in order for that to be true? Because like, if the company is like contacting me and I don't respond.
Well, at one point you have to sue them. If it passes
Okay.
2 or 3 years, you can't sue them anymore. Right? If you keep trying to reach out and get them to perform, let's say you performed your part and they didn't perform theirs.
Mhm,
They owe you money now.
mhm.
They owe you $10,000. You keep, or 15, whatever. You keep pinging them and they don't respond. You're gonna have to start a lawsuit. And that's what statute of limitations means, right? So if you don't, if it's past the statute of limitations, usually for simple contracts, 2 to 3 years, you can't do anything anymore.
Okay.
You can't sue them after a certain amount of time.
So after 3 years, you can't sue them?
No, you can't.
Okay. So it's not 3 years, now you can get out of the contract.
No, you can't get out. No, I'm talking in general. You can't, statute of limitations is you cannot take, you can no longer, when statute of limitations has passed, you can no longer take legal action against the other party. That's what statute of limitations means. So if you want to sue somebody, don't wait that long. Right? Okay. Damages that are awarded when somebody breaches a contract, there are compensatory, consequential, punitive, and nominal damages. Compensatory damages are pretty standard. It could be the sales of goods or lands. You have to deliver the goods or you have to give them the land, the payments and things like that. Construction contracts, damages depend on when it is breached, before, during, or after construction. have they even performed any of the work, or are they half done or has it been half paid and things like that? So, it doesn't have to be the entire value of the contract you're suing for, it could be halfway through, right? Consequential damages, foreseeable damages that result from a party's breach of a contract, but are caused by special circumstances beyond the contract itself. So in other words, so let's say I have a contract, I hire a contractor to remodel my bathroom. Contractor remodels my bathroom, but does something wrong with the piping, that there's a leak in my walls that damages the wall of my house. Now, my contract mentioned nothing about the walls, but because of the leak, as a consequence, my house was damaged, right? So that is consequential damages. I can sue him for fixing the plumbing and for the damage in the wall. All right? Questions about that? Yes, Diego.
So if you have a contract with like a manufacturing company for like a certain part that you're selling a product, and that isn't delivered because of something on their part, like say like the material cost increased more and they were like, we can't deliver this to you. And that causes you to lose business and things like that. Can you sue them for that, like
As a consequential
Yeah,
damage,
as a-
absolutely,
okay.
yeah. So if you have a contract with a supplier and the supplier does not supply you the parts as promised, which can cause you loss of sales and loss of profits, you can sue them for the profits you could have made, except if it was discharged because of impossibility to perform. Once it's discharged, you can't do anything.
So there'd have to be like a back and forth argument between like discharge, like certain categories of discharge. And like, so like discharge by like material, like costs or something like that.
Yeah, it has to be discharged first, but if it hasn't been discharged, yes, then you can sue them. Right. Does that answer your question? Okay. Punitive damages is kind of extra damages. Sometimes you don't even have to sue for that, but the judge will give punitive damages because it was such a bad case. The breaching party was so reckless. They're gonna give them extra punishment, right? It doesn't happen that often, but it can happen, right? Nominal damages, a small monetary amount, sometimes just $1, granted to the plaintiff when there were actually no actual damages suffered. Kind of a lawsuit just to prove a point, right? Questions? Diego.
Why do judges limit amount of punitive damages, at least for like when they're like, if we saw the McDonald's case, we saw that the punitive damages was in the millions and
Yes.
it was curtailed to I think a couple 100,000.
500 or something, I think, yeah.
I mean, I understand that like the significance of being awarded punitive damages in the millions can negatively affect the company because of media and things like that, but it's in the end, like they're not actually suffering any like consequence other than that.
Yeah, I'm not really sure how that was reduced because the judge was the one who called on the punitive damages, so I'm not sure afterwards, I don't know. But,
You know, because a couple,
that's what the media gets, and that's where the media will only keep the big number in mind. That's the way
yeah,
our media works, right? Yeah. You gotta have the shock factor and have 2 point some million versus 500,000, right? Yeah. Mitigation of damages, you are required, the non-breaching party is required to mitigate his or her damages. So if I have a leak in my house because a plumber did something wrong and I see the leak, I can't just continue letting it leak. I have to turn off the water to mitigate damages. If I don't, then I can't sue for the full damages, right? And that is, we have that law in place for people not to take advantage of somebody just because they made a mistake, right? Specific performance is an equitable remedy in which a court orders that the parties, the court orders the parties to perform the contract and the duties as promised, right? This remedy normally is granted only when the legal remedy is inadequate So in other words, if you're buying real estate, there's really no legal remedy available. You want that property. You were promised to receive that property if you pay X amount. And there's a contract that everybody signed, and they're not delivering the property. The courts might say, you have to deliver property. The property is now that person's property, right? And a lot of times in the case of land, right? Because there's only one of that specific land. There's nothing else that can be a remedy, right? And then contracts for personal services as well, right? Like in the case of hiring a specific surgeon to do the job and that not be subcontracted, right? Oh, I'm gonna go through this quickly. Recovery based on quasi-contracts. What is a quasi-contract? Again, we went through that, the first chapter of contracts is as if, yes,
A contract that's implied.
yeah, kind of implied. It's people are acting as if there's a contract, right? The requirements or the parties conferred the benefit to one on the other party. So I gave the benefit to the other party. The party conferred the benefit with a reasonable expectations to get paid. So I think we had an example of a water company that gave the benefit of water to somebody who wasn't actually, who they didn't have a contract with, right? So they delivered water to their house and the person received the water and paid, and the water company expected to get paid, even though they never had a contract with each other, right? The party did not act as a volunteer. The party receiving the benefit would be unjustly enriched if allowed to retain the benefit without paying for it. So it wouldn't be fair if the person that's receiving the water continues receiving it without paying for it, right? So you can have recovery based on quasi-contracts. That's it. Let me go ahead and stop the recording.